everybody. I'm Clark Hadley, Vice President of the Brighton Chamber of Commerce. We are here for our Expert Edge seminar. I've got Travis Tallarico here from Bond, Shank & King. He's going to be going over some of the real important information that any New York business owner, employee, employer really needs to know about the New York State HERO Act and some of the other changes that we've got in our state coming up here. So Travis, take it away.
Thank you, Clark, and hello everyone. Thank you all for coming, and thank you all for who will be tuning in virtually. As Clark said, my name is Travis Tallarico. I'm an associate with Bond, Shank & King. We're a law firm not only here in Syracuse, but we also have about 10 offices across the most and eastern seaboard. I'm an associate in our labor and employment division, but our firm handles essentially any sort of civil-related law matter that could possibly arise. So just keeping in mind for any legal needs that do come up in the future. So, as Clark said, today I'm going to be providing a bit of a brief overview on some of the major COVID-19 updates that have affected the labor and employment world over the past year. The three areas we're going to be touching on today is implementation of the HERO Act, religious accommodation requests in response to mandatory COVID-19 vaccination policies, and finally, COVID-19 related leave. So with that, we'll dive right in, and I guess I'll say at the outset of this presentation, I'm going to have a little bit of a Q&A session at the end for the people in the room. For anybody that tunes into this after the fact, please don't hesitate to reach out to me with any questions. I know I gave Clark my slides. He's more than welcome to distribute those to anybody who wants them, and my contact information is going to be posted at the end of this video. So to dive right in, Clark, if you want to jump to the next slide for me. So HERO Act activation. So starting with the activation of the HERO Act is a little bit of a background here. Back in July, the Department of Labor was required to formulate a model standard plan for airborne infectious diseases. And now those plans wouldn't have actually had to be implemented until whatever specific disease was designated. COVID-19 was designated as an infectious disease under the HERO Act back in the beginning of this month. So I'm going to be talking specifically about the activation of these plans and what they entail. But just as a little bit of background on this first slide here, so for some history purposes, by August 5th, private employers were all supposed to have a prevention plan into place, which should model one of the model plans provided by the Department of Labor. Those plans are all available on the Department of Labor website for any business owners here who have not implemented a plan yet or looked into this. I advise going to the DOL website and checking that out, and they provide you some nice templates. It's just simply plug and play for your business in accordance with their model guidelines. And as of August 5th, the only thing employers need to do is adopt a plan and do a verbal review of it with their employees. Next slide, Clark. Thank you. And so as of September 4th, employers were obligated to provide written copies of the plan to their employees. But this all becomes a little bit redundant because as of the next slide, on September 6th, the Commissioner of Health designated COVID-19 as a highly contagious disease and activated it pursuant to the HERO Act plans. And so now all of these plans need to be active and in effect. Next slide, please. So the implementation of exposure prevention plans. So this slide is obviously quite self-explanatory about what needs to be done, but now the plans are active, this is what all employers need to be doing. So reviewing the existing prevention plans and updating them if necessary. I would presume there shouldn't need to be too much updating done since these plans would have or should have just gotten developed a couple of months ago. Activating the plans, providing a verbal review with employees. I'll be going into that a bit more in detail on the next slide. Providing each copy with a copy of the exposure prevention plan in English or the language that is the primary language of the employee. Posting a copy of the plan in the workplace, and ensuring a copy of the prevention plan is accessible to employees during all work shifts. Now, what do we actually have to do now that the plan is in effect, or while the designation is in effect? Assigning enforcement responsibilities and ensuring that enforcement takes place. I'll be getting to this shortly, but one part of the activation is assigning a supervisory employee to be responsible for supervising and ensuring that the plan is enforced. monitoring and maintaining exposure controls. Those are things that are designated in the model plans, but relatively, I think, kind of self-explanatory at this point, using PPE, face masks, doing any sort of necessary cleaning, implementing employee screening procedures, following updates to guidance, and, as I mentioned, designating a supervisor employee to enforce compliance with the plan. So as I just said, I don't think that there would probably need to be too many updates needed to be done to any plans that are presently in place. Definitely staying on top of any updated guidance from the Department of Labor. There actually was a slight update that the DOL issued last night, which I'll be getting into momentarily, regarding the actual mask wearing policy. And then providing verbal review and training. And again, I'll be getting into what the verbal review and training of employees looks like in a couple of slides. So, per the language of the regulation, the employer shall conduct a verbal review of employer policies. So I guess in essence, it's, the question now is, well, what does this mean, and how do we do that? Which I will be getting into on the slide following this one. So this is just kind of a general overview of what the verbal review and training should look like. So these are all the things we're going to want to be touching on, right? So the infectious agent, so here COVID-19, the signs and symptoms of the disease, how it can be spread, explanation of the plan, areas of the workplace which may involve exposure or increased risk of exposure, the use and limitations of exposure controls, and a general review of the model standard, including employee rights. And I want to take a moment to talk about the employee rights provision, because there are a couple statutory rights that employees do have under this. So two main ones is, one, there is a no retaliation whistleblower policy, which essentially prohibits any sort of retaliation if an employee does report a business to the DOL or the Department of Health for non-compliance with the HERO Act. It also allows a civil right of action for employees to bring injunctive relief against their employers to get them to start enforcing the plans. In addition to that, this is not anything necessarily that an employee could bring, but there are civil penalties that the Department of Labor can remedy or can levy against employers for not following the plan. So this thing does have some teeth to it, and I would encourage anyone on the call who hasn't implemented this yet. I know it's something that might be easy to kind of push by the wayside, but especially given the governor's relatively aggressive new stance on combating COVID, I would say definitely this is something that we want to make sure that we have in place. And so the training must be provided at no cost to employees, taking place during working hours. If that cannot happen, or if employers need to come in, or employees need to come in on their time off, they must be paid for it. And it must be verbally provided in person through telephonic, electronic, or other means. So with that, we do have a couple options of how the trainings can be delivered. It can be an in-person event like this. It can be a pre-recorded training session that you can send out to your employees to just watch. Similarly, a Zoom meeting, or, well, I guess pre-shift kind of covers an in-person meeting, but just having people come in 15 minutes early to discuss training of the plan. So next, we have a few commonly asked questions that we've been getting from some of our clients, and again, I expect there to be plenty more, so anybody that does tune into this, please don't hesitate to reach out with specific questions that I don't touch on today. But can we make changes to our plan? Yes, absolutely. You're supposed to, in accordance with any updates with your business or that the Department of Labor rolls out. Do we now have to require our employees to wear masks at work? So the general answer to this question is, even vaccinated or unvaccinated, generally speaking, yes, when social distancing can't be maintained. So now if people have their own offices or their own spaces that are socially distanced, that shouldn't be any sort of an issue. But as a general best practice, we definitely advise, whenever social distancing cannot be maintained, vaccinated and unvaccinated employees should be wearing masks in the workplace. Now, as I alluded to a little bit earlier, the DOL did slightly revise this guidance yesterday, which does state that if all employees and any other people in the business, so guests, vendors, whatever, are fully vaccinated, then masks can be optional. So this is kind of an example of how they're always, the state and the Department of Labor are always constantly tweaking things, and I know it must be a challenge for for all of you tuning in and everybody here to stay up to date. Frankly, it's a challenge for us to stay up to date on these things, and we're the experts on this.
Now,
Yes.
I have a question about that phrase here, to require it. How do you monitor that? How do you police that?
So I would say in terms of monitoring, obviously a little self-explanatory in terms of just watching and seeing if everybody's wearing them. If any employees report other employees for not wearing masks, and then that likely becomes an internal disciplinary procedure, and that's something probably that would be a good idea as a best practice to establish for for all businesses. What are our action steps, or how do we want to handle employees that might be a little non-compliant with following these this mandate, and particularly the unvaccinated ones.
Is there any precedent for like what those punishments have been? Like, have you dealt with any clients that have had to handle that situation?
Personally, I haven't dealt with any myself just yet. I would imagine across the firm it's been an issue. Again, being that this is the HERO Act just got activated earlier in this month, the actual necessity of enforcing it has been a little bit lower. Now it's there's a bit more priority to be doing so. So unfortunately, I don't have any real life examples of this just yet, but I could imagine it could be some sort of probably gentle progressive discipline. Start with a couple verbal warnings, and then if it really becomes an issue, then then escalate things, because at the end of the day, this their non-compliance is then making the employer out of compliance with with the HERO Act. So
you were talking about doing pre-recorded review examples. Is that something that is on the Department of Labor, or are you saying we ourselves pre-record it and email it to them?
that's something that's a great question, Harry. That's something that you yourself would want to do.
I gotcha.
And with that, it does. So we have actually gotten this question where it's for larger companies that have outside vendors do their compliance stuff for them. We've gotten asked the question, hey, can we just have our third-party company put together a verbal training for us, or kind of just sort of a blanket training for all of their clients, and do it that way? The answer to that question is no. It does need to be a customized verbal training for each individual business. So that is something that, and again, it doesn't need to be anything incredibly comprehensive. You want to just be touching on those bullet points that were earlier in the presentation. But that is one thing. It does need to be customized for your specific business.
Thank you.
Does that require then that, from a pre-recording, right, somebody could be doing it at 9 o'clock at night, do they have to confirm that they've taken the training?
Yeah, so you would want to get some sort of, I would recommend if there is if you're doing it in the pre-recorded fashion, that you get an attestation from your employees saying that they watched it, reviewed, and understood the training. Probably sign off on when they did that. Okay, so do we need to provide a copy of our disease prevention plan to people other than employees? No, generally speaking, if you have vendors, contractors, customers coming in, there's no obligation to provide the plan to them. Do I need a HERO Act plan if I have fewer than blank employees? The answer to that question is, generally speaking, going to be yes. Even employers with just one employee do need to have a HERO Act plan. The DOL did confirm for us either last week or the week before that individual sole proprietors do not need to have a plan. So just one man or woman shop, they don't have to have a plan, even if they are having some customers coming in and out. And when do I have to activate my plan? The plan should, as of September 6th, the plan should be in place. So again, for anybody that's tuning in here, if you don't have a plan, hop on the DOL website and get one going, and do the necessary activation procedures with your employees. And again, we and my firm are here to help advise on that if necessary. All right, so next we're going to be moving on to religious accommodation requests to mandatory COVID-19 vaccination policies. Now, this may seem like a little bit of an odd or an obscure topic to some of those tuning in, but I believe that this is actually going to be a very, very hot topic over the next few months, particularly as not only private employers either decide or are mandated to roll out vaccine mandates. I can tell you this is something that we've been seeing extensively from all of our healthcare clients that are affected by the mandate that was released a few weeks ago requiring all healthcare workers to be vaccinated. Even in the last couple of weeks, we've been getting inundated with questions from all of our healthcare clients about what the necessary standards are to go to grant a religious accommodation, and particularly under the mandate, which this may be a little bit outside the scope of discussion for most people here. There was not a religious accommodation option available for healthcare workers under the mandate. Now, a couple of weeks ago, to complicate things even farther, Judge Hurd in Utica issued a temporary restraining order prohibiting enforcement of the religious accommodation provision for healthcare workers. So that regulation the mandate went into effect on Monday, and I'm sure probably a lot of you have been hearing about it on the news, especially down in the city with some of the hospitals having some big layoffs, but it's definitely going to be a very pressing issue, because we have been seeing, even just from all of our healthcare workers or our healthcare clients, lots of these requests. So I definitely think it's worth even business owners with 1, 2, 3, 4 employees having an understanding of what this looks like if you do see one of these types of requests coming across your desk. So as a brief overview, because I know a lot of us might not be particularly familiar with what a religious accommodation even is in the first place. So under Title VII of the Civil Rights Act of 1964, so the federal controlling law in this area, it is an unlawful employment practice for an employer not to make reasonable accommodations short of an undue hardship for the religious practices of the employer's employees and prospective employees. And the term religion encompasses all aspects of religious practice as well as belief. I'll be extrapolating on that in a couple of slides here. Pardon my coffee break. So there's a little bit of legalese in here, but just to kind of lay out what it actually looks like to establish a viable religious accommodation case. A plaintiff must first demonstrate that they held a bona fide or sincerely held religious belief, that they informed their employer of the belief, so the employer was aware of it, and that they were disciplined or otherwise suffered some sort of adverse employment activity as a result of their religious belief. So once a prima facie case is established, the employer then must offer a reasonable accommodation to try to accommodate that employee in their belief, unless doing so would cause the employer to suffer an undue hardship. And again, I'll be kind of expanding more on what an undue hardship is shortly. And that is whenever it results in more than a de minimis cost to the employer. So how is religion defined? So at least here in New York, religion is defined very broadly. What's important to know, a few things I want to highlight is it needs to be tied to some sort of a religious facet or religious belief. It doesn't matter how strongly held the belief is, if it's based on scientific grounds, personal reason, whatever the case may be, it does need to be tied to some sort of a religious belief or facet. So if somebody says, I don't want to get the COVID vaccine because I've done XYZ research, whatever they come up with that isn't tied to some sort of a religious belief or tenet, then it would not be protected under these protections. So as I kind of alluded to there, social, political, or economic philosophies are not protected. Now, it is generally recommended, and this is something that we've been discussing at length with our healthcare clients, but it's recommended that if an employee does come forward asserting that they have a sincerely held religious belief, to take that at face value and likely grant the request. Now, with that being said, the EEOC did release guidance at the beginning of this year that does explicitly grant the employer a right to inquire a bit farther if the employer needs to understand or has legitimate reason to question the sincerity of the belief. So this is something, for the sake of this presentation, it's probably not worth getting into the weeds here, but it's something I think that all companies need to think about and how they want to set these types of precedent moving forward, right? So I guess where I'm going with that is it's important to establish one sort of standard on how we're going to treat these kind of requests, and once we do, to treat all subsequent requests uniformly, because now this could open the door to some potential liability where if you have letter A from employee 1 and letter B from employee 2 that are marginally different in what their religion is or what their reasons are, and you grant the request for employee A but not employee B, now we're talking about some exposure there. So, what is a undue hardship or more than a de minimis cost? Unfortunately, I don't really have a clear-cut answer to this question because I can't. This is something that does need to be determined on a case-by-case basis, and it'll vary on the type of employer, what the request actually is, and the nature of their business. But some examples of this are costs, so that's just purely economic cost to the employer granting the accommodation, interference with workplace safety, legal risk, violation of existing company policies or seniority systems, and disparate impacts on other employees. So with those last two, an example of that is something that we would see a bit more, would be examples of employees that would say that they can't work certain shifts due to their religious beliefs. Now, those are requests that are commonly granted, but those requests cannot be granted if they would have a disparate impact on other employees. And so those two that I have bolded there, though, the interference with workplace safety and legal risk, there is plenty of case law out there, both from New York and on a federal basis, which states that an employer is not obligated to grant a religious accommodation request, and that it would be an undue burden if it would result in a significant increase in or interference with workplace safety, or put the company in exposure for legal risk. So some examples of this, just so we can kind of wrap our heads around what this looks like a little bit. There's a case from the Second Circuit where, regarding the interference with workplace safety, it was an employee who wanted to wear a form of religious headgear at all times instead of a hard hat, and essentially the determination of the court there is he worked in kind of an electrical environment, and so not having a hard hat on and having that amount of cloth in an environment where it could catch fire would pose a significant impact on workplace safety, and denial of the request was fitting there. And legal risk is particularly relevant, especially for our healthcare clients. This is something we've been talking about with them. If there is a conflicting either state or federal mandate, which granting the request would put the employer at odds with that regulation, the employer is not required to grant the request. And so that's what we've been seeing and wrestling with these religious accommodation requests with the state mandate is, prior to the TRO, when they were clearly not allowed under the mandate, is a position that we were taking with our clients. Hey, if we grant these types of requests, that's going to be putting us at odds with the mandate, and thus likely would not be required to grant those requests. Hopefully that was not too much information, but just trying to put some of this stuff in context a little bit for us. So what are some possible accommodations? As I've said, for healthcare workers, it's very much up in the air right now, given the pending TRO. But for everybody else, a lot of this is probably self-explanatory, but mask mandates and social distancing, allowing employees to be able to work remotely, mandatory testing. And a note about mandatory testing is, if that is granted as an accommodation, that is a cost that does need to be borne by the employer. So you can't require your employees to pay for their testing if you are granting that as a accommodation request. Relocation to a different role. So essentially, if you had somebody that was kind of coming into contact and working frequently with other customers, vendors, employees, and you could shift them into more of, say, an administrative role where they are just in kind of their own office that day. When they come into the office, they're not really exposing anyone. That could be an option. Shift changes and allowing the use of paid time off for new job search and helping them with the job search. So with this last one, this is something that we have been seeing with some of our healthcare clients. We've been advising that they grant employees as an accommodation at least X amount of period of leave while this is pending, or even for those that aren't coming forward with a request, to grant them additional periods of leave to help them, to give them a bit of extra time to find a new job. And that theory has been extrapolated in some case law that I've reviewed, particularly in the religious accommodation setting, where It was a hospital network. They went through the interactive process with the employee. And this was regarding a flu mandate, notwithstanding COVID. They found that it would be too much of a risk to be putting a non-flu vaccinated employee in front of their patients. And they did grant the employee, allowed her to use her paid time off, granted her some extra paid time off, and actually got their HR department involved to actively help her look for a new job. So again, since these all need to be kind of a case-by-case basis, and this is ultimately up to you all as business owners is how you want to handle these. I don't have a direct answer of what you need to be doing, but these are just all some options I at least wanted to lay out. And so, as I've said, there's not really going to be a scenario where there's really necessarily a cut and dry answer here. There may be a few of them. Then the example I'm thinking of is if you do get a request which is completely secular in nature and has no tie, I think that's a pretty safe basis to deny a request like that. But otherwise, it is very important to at least engage in the interactive process with your employees, understanding their belief, understanding what their requested accommodation is, understanding what you as a business can do to possibly accommodate them, and then making the decision from there. All right, and next, and kind of our last topic here this morning is going to be COVID-19 related leave. So the first part that we'll be talking about is the leave that's available for employees that are subject to a mandatory quarantine order. This has been in effect since March 18th of 2020, where Governor Cuomo signed as part of one of the many bills that he signed, provides employees for job-protected sick leave in the event that they are subject to a mandatory quarantine order due to COVID. So are we on? I think we.
Did I skip one?
Nope, that's good. So the amount of leave which needs to be granted is based upon the size of the business. So private employers with 10 or fewer employees and who reported less than $1 million in new income in the previous tax year must provide unpaid job-protected sick leave to any employee who is the subject of a mandatory order for the duration of the order. Now, for these employees, there are still a couple of options of how they still can get paid. They still may be eligible to receive compensation for their time off of work through New York State paid family leave or through statutory disability benefits, which are available to employees that are subject to these kinds of orders. And so, conversely, private employers with 10 or fewer employees, but they reported more than $1 million in the previous tax year, and private employers with 11 to 99 employees must provide at least 5 days of job-protected paid sick leave, and then from that point it converts to unpaid sick leave until the termination of the quarantine order. And again, similar as the employees described on the previous slide, after the 5 days of paid sick leave are up, then the employees can still seek out compensation through New York paid family leave or through the statutory disability benefits. And private employers with 100 or more employees and most public employers must provide at least 14 days of job-protected paid sick leave throughout the duration of the order.
Are these regardless of why they're on, like, my big concern these days is someone comes into the office and we all have to quarantine. So that person, I don't need to provide paid leave even though they got it at the office where they're working?
Could you restate that?
Like if somebody were to come into our office,
right,
and in a situation where we all had to quarantine,
sure,
those workers still are not required to be paid if we have less than 10 people and brought in less than $1 million last year. Their 2 weeks is unpaid.
Yes.
Wow.
Yep.
It's kind of dirty.
Yeah.
No, I see. I wasn't saying that I wouldn't. I was just that seems kind of dirty. Surprised
Well,
by that.
I think that's more for to kind of alleviate any sort of burden for for smaller employers there.
Right. Yeah.
Although I mean the whole concept of also because the whole concept of paid family leave is paid family leave is generated through the payroll system, right? And so those claims are diverted to an insurance company. So rather than for bigger employees, I presume the onus is, all right, well, you can afford to be paying your people. Where for smaller employees, it's like, hey, well, let's take the burden of actually paying them away, and we can shift that into paid family leave, or the state's picking up the buck on that
Is
one.
that paid family leave fairly close to their standard pay? I'm just curious how it works.
Yep, no, that's a great question, and I get into that. Oh, actually, look at that,
Oh,
Harry.
sorry.
Perfect.
Smooth transition for you.
So I did want to give, because I had a feeling there was going to be some questions about what paid family leave really is. So thank you for that segue. That was perfect. So employees can use it in the COVID context to either supplement their wages for themselves when they're out on a quarantine order. They can also use it to care for a family member who is ailing with COVID. I actually just got this question from somebody in my office where I think it was her brother's mom or something like that was sick and was wondering what options they would have. So eligibility is employees are eligible when they work a regular schedule of 20 hours or more per week for 26 consecutive work weeks. And just an important little asterisk there is that 26 consecutive work weeks is with the same employer. So if an employee does jump ship to a different company, that resets their eligibility for paid family leave. Part-term workers are covered as well, those that work less than 20 hours per week. And now this is eligible after working 175 days for the employer, notwithstanding any sort of a consecutive basis. So excuse me, this is something that for those that do have part-time employees, it probably would be a best practice to, and obviously you can just go back and look through your payroll records and kind of tally up how many days they worked for you, but for determining PFL eligibility purposes, that is something that you'd be wanting to track. And so under PFL, employees get 67% of their weekly salary, and this is not the current cap is a little bit lower than this at the moment, but as of the start of the new year, up to a cap of $1,068.36. Now, this can also be combined with statutory disability benefits, so an employee can apply for both. They can apply for paid family leave, and they can apply for their disability benefits. Their disability benefits go up to a cap of around $2,000. So when you put these two together, the cap is roughly around $2,800 or somewhere in that realm. Now, with this all being said, that's likely a pretty high weekly salary for most employees, and any sort of benefits that employees receive under disability or paid family leave cannot exceed more than 100% of their salary. So under either paid family leave or their the disability benefits or a combination, it would get capped at whatever their maximum salary is. And that's kind of the whole purpose of, at least for the application and the combination of both of these for COVID, is to just ensure that employees are still earning their full weekly wage while out on leave.
Just to clarify, the 175 for part-time, that means they had to have worked that many days, not like it's been 175 days since they were hired?
Correct.
So if they work 3 times a week,
yes,
yes. 3 per week.
Exactly, working days, yep. So that's why I was kind of alluding to actually tracking the specific days that they worked.
I never would have thought that, thank you.
And so now some important things to know about this leave though. So the leave that we just talked about is not available for employees that are subject to an order, that are not showing symptoms, and are able to work remotely. So obviously that that poses a little bit of a question as to if an employee is actually experiencing symptoms or not. I don't really know how you necessarily regulate that, but it's something definitely to keep in mind, particularly if they do have the capacity to be working remotely. And also importantly, now if an employer requires that an employee remain out of work who is not subject to a mandatory order, the employer must pay that employee for that time off until that they are allowed to come back to work. Situations like this may arise just if an employer, I guess, wants to be a little bit more cautious now with the 10-day duration of the quarantine orders. If they want to take it a little bit farther and make it be 14, if they require the employee to stay out for an extra few days, they do need to pay them their full regular salary for those days not allowed to work. I can't say I've seen this come up too often, and I really hope it doesn't for most people, but after 3 orders of isolation, employees are no longer eligible to the benefits described above here. Like I said, I haven't heard of an employee that's been subject to and received 3 paid COVID leaves yet. And also the leave that we just discussed must be provided without any sort of without inhibiting any of their previously accrued sick time. So with those, for the employers that need to be granting some paid sick time, you can't deduct that from a previously earned sick bank that they already had. COVID-19 vaccine leave, this might be a little bit less topical now that the majority of the population has had the opportunity to get vaccinated. But just as a refresher for both public and private employees, employees are entitled to 4 hours of paid leave for each vaccination. It doesn't need to be a full 4 hours, but whatever their time is spent, going, getting their shot, coming back to the office, whatever it may be. And now, kind of in relation to this as well, the Department of Labor released some additional guidance which provides that employees are allowed to use their leave that they've accrued under New York paid sick leave, which I'm going to be discussing on the next slide, to use time off for vaccine-related symptoms. Now, one question that I assume might be posed, and frankly that I've been wondering about myself, is if there is going to be a third round of this leave, which is granted for assuming when the boosters roll out. I would, if I had to guess, and particularly the way the current governor is handling things, I would guess that she is going to say yes, there will be a third round of paid leave available for employees to go get their boosters, but that is simply a speculation at this point, so please don't hold me to that. And finally, this isn't particularly COVID related, but I did at least want to bring this up because it's topical for all employers and applicable to any employer with more than one employee. So this New York paid sick leave went into effect technically beginning on September 30th of last year, and by effect there, I mean the accrual of paid time off, with employees actually able to start using their time earned under this regulation as of January 1st of this year. So essentially that mandate now requires that basically all private employers in New York State need to provide some form of sick leave available to their employees. And we will get into the next couple slides of the amount of that leave based on employee size. So this is kind of structured similar to the categories of leave given for COVID leave, but employers with 4 or fewer employees who reported less than $1 million in taxable income are required to give up to 40 hours of unpaid sick leave every year. For employers with 4 or fewer employees with more than $1 million in reported income, up to 40 hours of paid sick leave. The same for employers with 5 to 99 employees, 40 hours of paid sick leave. And for employers with 100 or more, up to 56 hours of paid sick leave per year. So how do we track, how does this get accrued? So there's a couple different options we can take with this, right? So you can do it on an accrual basis, so employees must earn 1 hour of paid or unpaid, depending on which classification you fall into, leave for every 30 hours worked. Alternatively, an employer can choose to front load the sick leave at the start of the year. So you could just, at the start, just give your employees 40 hours of their sick time, 56 if you're an employer with 100 or more. The only thing with this though is that once an employer grants this time, it cannot go back and retroactively pull back any sick leave based upon any actual hours that are worked. So once this time is granted, it's available for the employee for the rest of the year. And this time can be used, it's very flexible of what this can be used for. It can be used to care for any mental or physical, essentially health condition of the employee, the diagnosis and treatment of such, and it can also be used to care for the care of any family member. And the definition of family member under the regulation is relatively expansive. It's not just limited to mom, dad, kids. It expands to parents, step-parents, step-kids, things of that nature. And with that is all of the material I had prepared for today.
Sub-employee is a full-time employee by the definition of that employer.
Say that again?
When they're talking about employees, they're talking about a full-time employee.
Part-time employees too.
I'm thinking about a friend of mine who's a CPA, right? He's got two girls two women who share, the administrative type role, One works 2 days, 1 week, and then the other works 3 days, and the next week they swap that time frame. But they're not, they're not full-time, 40-hour type folks.
Part-time employees are still covered as well.
Okay.
Yep, it's not just full-time employees. So for those part-time employees, I would say probably the best practice with that, especially if they're only, if they're only working 10, 20 hours a week, to do it on the accrual basis and, just track their hours, and every 30 hours give them an hour paid sick leave. Because even if the legislation says up to 40 hours, so, I mean, theoretically, you could have an employee that does not hit that number on the accrual basis threshold, right? So if they're only, they're getting an hour for every 30 hours worked, obviously if they only work a couple hundred hours per year, they're not gonna hit 40. So for part-time employees, I suggest using the accrual method.
Have you guys run into any issues, especially for healthcare offices that are kind of like private practice, where the owner is also the employee? And like, have you ever seen that situation where that owner-employee, is it hard to like grant yourself a religious exemption, for example, for some of the people in private practice, especially for, like, it seems like that could get a little hairy if you start granting yourself exemptions?
Yeah, that's a good question. I mean, is there? No, frankly, it's pretty easy to do that, right? Because you're the decision maker, the business owner is the decision maker, and if they want to grant themselves an exemption, they can grant themselves an exemption. Now, with that being said, I would be very cautious to do that, or particularly with, if you do that for yourself, I would imagine any other requests that you get, you would want to grant.
Okay.
I can see why you're gonna have a little bit of business coming in, and why you exist.
Yep.
Because it can be challenged in so many different ways.
It is. It really is.
It requires an attorney to define and specify what was it.
Right, and that's, frankly, that's something that is even hard for us. Is we have about 80 employment attorneys across Bond, and this is something that we have had numerous conference calls on whenever the various regulation comes out. And it's a lot of internal discussion with us to pick this apart and decipher, hey, what does this actually mean? Because heaven forbid the state could actually provide clear-cut and guidance which the layperson can look at and say, okay, I understand this and this makes sense to me. But yes, unfortunately, you're right. As COVID definitely is keeping us busy. But obviously, that's what we're here for any of our clients, and just anybody on that's tuning in. Any general questions that you have, I'd be happy to field. Just kind of off the record, just to provide some advice during these last year and a half of trying times that we've all been subject to.
Guys, do you have time for?
I have plenty of time.
So, as the year ends, is there something that needs to happen to any unused sick leave that they have acquired? Does that need to be rolled over for them? Or does it just go away? Then that's fine.
I would need to refresh myself on the rollover, honestly, of what that looks like, if there's a required rollover or not for the paid sick leave. I think that there is. I can follow up with you on that.
Thank you. Yeah.
I should know this off the top of my head because I actually just kind of did a fairly big research project on this, but I'll follow up with
Thank
you.
I appreciate that.
When I confirm that.
Is there similar requirements for vacation time? Like if someone wants to, they're taking care of their kid, they used up their family time, and then they want to use their vacation. Are there required vacation days similar to the criteria we got here?
Vacation days, I would say no, not really, because any sort of additional PTO like vacation,
like non-paid or non-paid days is where
anything that's not specified that I just went over, there shouldn't be any additional obligations on employers other than this. From that point, that's more up to the discretion of the employer if they want to grant some extra vacation days, allow their employees to use them.
For sure.
So, essentially, any PTO that's not regulated by state or federal law is up to the discretion of the employer.
I got you. Thank you. Just wanted to make sure I wasn't missing any.
Yep.
All right, thank you very much, Travis, for coming out with a really information-packed seminar. If you guys have any questions, like you said, just reach out to him. We're going to get the slides that he gave us available online along with this presentation as well. If in the future you want to ask questions in person at these seminars, you're more than welcome to come and be here while we record them like we've done here today. And thank you again very much. We look forward to learning more from you in the future, and hopefully we've got ourselves covered now.
Thanks, everyone.
Good job. Really important.
Good job.
And And one last thing, everyone, I just wanted to make you all aware that my firm, Bond, we do weekly webinars on not only COVID-related issues, but general employment-related concerns, essentially kind of what the weekly hot topic in employment law is. And those webinars available completely free of charge. Just go on our website, bsk.com, and you can register for those. And then once you're signed up, you'll get weekly emails, notifications about what the topic of the week is, and instructions on how to tune in. And thanks again.